SJC-13668 in the matter of an impounded case.
We're gonna break after this one, too. Yeah, for sure.
Okay, Attorney Driscoll-Weiss, whenever you're ready.
Thank you, Your Honor. May it please the court, Roberta Driscoll-Weiss today on behalf of the Appellant children. With me is Attorney Jamie Wallerstein, who is trial counsel for the children. I have two requests of the panel today. First, I would ask that this court rule on the application of the interstate compact for the placement of children, which I will be referring to as the ICPC for the rest of my argument. We're asking the court to hold that the ICPC applies when a child is sent across state lines for the purposes of foster care or adoption, not, as was proposed in this case, for a custodial determination of custody through a guardianship. And
Can you explain to me what the status is of the guardians, as I understand it, or proposed guardianship? As I understand it, they are not present, participating in this appeal.
The guardians filed a motion for a late notice of appeal to join with
Right, and that was
child's brief.
denied without prejudice I just don't know if they actually did file a notice of appeal.
They didn't file a notice of appeal, Your Honor. What they filed was a status report indicating their continued commitment to these children, as I noted in my reply brief.
But aren't they a necessary party for these proceedings?
I think,
That is, what remedy should we order, you know, assuming we agree with your argument? We don't have a guardian before us as a matter of their posture in this case, that whose rights are being affected.
in their status report, they did indicate their continued commitment, which I would aver again today. But as I pointed out in my reply brief, this is a matter that is certainly capable of repetition, yet evading review, and in fact could be repeated.
So we would say this matter, we can't decide for these particular children because we need the guardians present in order to affect their rights, but going forward, FYI, the ICPA doesn't apply or does apply?
I
Just
would,
sort of as a dicta, you know.
Because you seem to be melding in a mootness issue, and that's not really what this issue is. This really is a question of whether or not whatever we do, let's say we agree and you win, right? We don't have the great aunt and uncle saying, yeah, we would like to do so. Forget about previous flares about they would be willing to do so. We don't have that here.
then what I would ask this court to do, Your Honor, would be to remand the matter back to the trial court for an evidentiary hearing on the suitability of the proposed guardians, in essence, to rehear the petition for guardianship in the trial court with an evidentiary hearing, which was denied.
But by not appealing, the guardians have accepted the finality of that decision.
And I think that's my point, Your Honor, is that I don't think that they did. I think that.
But how do I know that? It's just this notice of continuing interest that you're saying I should read as effectively an appeal?
Yes, and in fact, Your Honor, they could simply file another guardianship and start the whole process again. When I say this is capable of repetition, it could be repeated in this exact same case again. And so I think as a matter of, judicial economy and as a matter of law going forward, the ICPC, as we all know, is something that is we are being confronted with quite frequently in recent months and weeks, and so I would ask the panel to hear the
You don't
argument on the merits.
represent the proposed guardians, do you?
I do not. I represent the appellant children.
Right. And I didn't see the status report that you're referring to. I didn't see it in the record. Is it in the record?
I included it in the addendum for my reply brief. I believe
Okay.
it's the last 2 or 3 pages. What we received from the appeals court was essentially directive pursuant to guardianship of Tara, where in guardianship of Tara, there was no indication at all that the guardians had any continued interest in serving as guardians, and so the status report was an attempt to address the specific directive from the appeals court about their continued commitment. Their request to appeal was to simply join the brief that I filed on behalf of the children.
So the guardians have joined your brief?
No, that was their request when they filed the motion for a late notice of appeal, was that they just simply be allowed to join the child's brief, not to hold up the matter by filing a separate brief. That was the motion that was denied, Your Honor.
Were they represented by counsel in the trial court?
They were not, and they're not represented by counsel now. And I apologize if the status report was inadequate. I would perhaps.
Well, normally you'd need to appeal a decision below in order to participate. But I take it that all we have is the status report.
And again, Your Honor, they would certainly today file another guardianship petition in the juvenile court.
Or a notice of appeal.
There may be problems with that, but can we get to the merits? Because,
Yeah.
so you rely on this law review article, this Yale Law Review article for your substantive position. Is that a distinct minority position, both rejected by the feds and the state, or is there, I'm just trying to get a sense of, I understand academics often, think we're over-reading things or under-reading things, but is this a distinct minority position you're pushing?
I don't believe that it is, Your Honor. I think in my brief, I outlined that there are a number of other jurisdictions that have held, as I would be asking this court to hold, that the terms of the ICP as drafted, as codified in 119 App Section 2-1, very clearly state that the purpose of the ICPC is first to create uniformity.
But just to push you a little bit, are there any cases like this, as opposed to a family type of guardian? Someone gets divorced and they're shifting. Are there any cases like this where a court in a DCF type of case has done this kind of thing and it's found to be permissible? Because I read through quickly your cases, at least the parentheticals, they seem all distinguishable. Are there any cases like this where a court is assigning out of state and the receiving state is rejecting it? Anything like this?
The In re Imoni case in New Hampshire, I believe, was a similar state intervention type of matter. If not, I would be happy to respond by letter. I apologize, I can't answer the question at the moment. But I think just going back to the substantive argument, there's one reading of the ICPC that both comports with the language of the statute and therefore the legislative intent in adopting the statute and the other relevant statutes that come into play in these types of.
But it's rejected by the regulations, right? The regulations say the exact opposite.
Well,
It's a question, not an answer yet. Is that right? The regulations reject your interpretation, right?
the DCF, as the compact administrator, is allowed to promulgate regulations that aid in the furtherance of the compact itself. And I argue that their regulations are overreaching and overbroad, given what those regulations are intended to do. They're intended to assist DCF as the compact administrator in administering the compact. But the compact as written is very clear that it refers to placement, not custody. It never doesn't use the word custody. It uses the word placement. And it applies to placement for the purpose of foster care or adoption. And when you look at the other relevant statutes that are implicated in child welfare cases, like 190B, which is the guardianship statute, 209B, which is the child custody jurisdiction statute, there are very clear there's very clear antagonism between them. For example, Section 5 of the ICPC requires that the sending agency, in this case, Massachusetts, would retain jurisdiction over all matters pertaining to the children, healthcare, schooling, etc. And if you think of a guardianship case, the guardianship statute very clearly says that these are responsibilities that are given to the guardian.
At least for the initial transfer, right, guardianship, and here the guardians, the grand guardians are on all reports wonderful people and it'd be a great match. But if that were not the case, how does DCF ensure itself that they're not sending these children to a bad situation in another state?
So, which is, and in my brief, I argue that the children were denied due process because there was no evidentiary hearing. In a guardianship petition, the petition is filed with notice to the other side, requesting a full evidentiary hearing, in which case the home study from a licensed adoption agency in Pennsylvania, which was, as you know, glowing, and she went as far as to say, I don't ever make recommendations, but in this case I'm going to, and I'm going to recommend these folks as guardians because they are perfectly appropriate. This is a matter that should have been tried before the judge. The judge should have...
It should have been tried in here or in Pennsylvania, because it seems like your beef is with Pennsylvania, that they're doing something unconstitutional by depriving these very capable guardians based on something that happened 17 years ago. But there's got to be a way of appealing that in Pennsylvania. Well, it has to be. If something's unconstitutional, I mean, I'm not an expert in Pennsylvania law, but it seems like you should be in Pennsylvania, not here.
If I could just clarify one point, which, and I think it was not clear to me until I read the department's brief. The statute in Pennsylvania that the ICPC compact administrator in Pennsylvania relied on in denying the guardian's home study is a statute. It is, pardon me, 23 Pennsylvania CS 6344, and it applies to employment. So it's a statute that governs who can be employed to or volunteer with children. So a Boys and Girls Club or a daycare center this statute would govern those individuals. And it applies to foster parents. It does not apply to guardians. And yet the ICPC provides no independent right of review in Pennsylvania for a family who's been denied an ICPC home study. And when you contrast that with Massachusetts, which, for example, the testimony or the commentary by the DCF attorney during the hearing was, if this was Massachusetts, we would have waived this criminal record issue. It was 26 years ago.
But how does that not make Justice Kafker's point? Because what we're looking to here is, what did the trial judge here do wrong? And if the beef is, we couldn't appeal it in Pennsylvania. Pennsylvania, even though you're saying potentially whatever they use to deny the placement is not applicable to a home study for a guardianship petition, that's all Pennsylvania's stuff. So why is it that the trial judge was wrong here to say they won't receive it, so I'm dismissing it?
Because the ICPC shouldn't apply in the case of a guardianship. And that's why I say when you look at the ICPC together with other relevant statutes, 119.26 says that after parents are found unfit, the judge has a list of options available to him or her. One of those options is to give custody to any person that's in the best interest of the child. But here we have the ICPC that says, well, sorry, judge, you can't do that because we have this foreign administrative agency that has made this anonymous declaration that these people are not suitable
Okay,
and there's no right of appeal.
Well, let me just press this a little bit. So you're saying that the regulations where they say it does subsume guardianship, even though you're saying that the ICPC does not say that there's this disconnect with how they're looking at it. Well, if the ICPC calls for adoption, and we agree that it says adoption, how can a lesser placement not be within be subsumed by the ICPC?
But I think it could.
Well,
I
the
think-
regulations say it could.
But I think the difference here is the manner in which children are placed for adoption. They're placed by DCF in a home that has been licensed or is undergoing licensure for adoption. It's not the judge that places the children with those particular individuals, it's the department. Guardianship is a different animal altogether because it's a custodial determination made by a judge after an evidentiary hearing. So we're not saying that DCF made a mistake here by not placing the children. DCF's hands were tied. But I don't believe the judge's hands were tied because the guardianship petition was a vehicle to get these two children who, if I could go to the second portion of my argument, is these are two children who are placed separately. One has a potential adoptive placement that will not adopt the other. So the only chance that these two children have of being raised together and being raised together with family was this guardianship petition.
Well,
And
no,
I-
there's another chance, which is, had you brought a lawsuit in Pennsylvania and fixed this, Massachusetts would immediately send the kids there because Massachusetts is comfortable with this. But what you're asking us to do is you're asking Massachusetts to send these children somewhere where Pennsylvania said it's not appropriate. And that's a much more complicated problem than
Respectfully, Your Honor, and I apologize if that's the impression that I gave, because that is absolutely not what I'm asking. What I'm asking Massachusetts to do is to look at the four corners of the ICPC and decide that this is where the ICPC applies, as it is drafted, as it was adopted by the legislature, and if in that circumstance, what the trial judge found here was, these are great people, love these people, don't have any problem with these people, but the intent or the spirit of the ICPC is violated here. And what I'm saying is the spirit of the ICPC doesn't apply to a guardianship at all. It's the difference between an administrative agency placement and a custodial decision by a judge. And I think to tie the judge's hands by this broad, expansive, and really unsupported reading of the ICPC is to do the juvenile court a great disservice. This is, not only is this capable of repetition in this particular case, but this is a situation that we face in the juvenile court almost on a daily basis because of the ICPC.
May I ask a question? Was your petition a permanent guardianship, petition for permanent guardianship?
Yes, Your Honor.
Okay, and if I recall the rules for permanent guardianship correctly, which is unlikely,
I doubt that very much.
there's some continuing reporting requirement that goes back to the court.
Yep.
It doesn't ever get transferred to the jurisdiction. Does it ever get transferred to the jurisdiction where the children then end up residing or the guardian resides?
It does, and the guardianship statute provides in section, I want to say 7, I could be wrong. The guardianship statute provides for guardians to remove children out of state. That's something that's contemplated within the 209B.
And once removed, they start reporting to the local state.
And then what would happen is one would take that petition and register it with the foreign court and,
Which we can't do here.
which you could do here. I apologize, but
So you're saying if the guardianship were approved here?
Yes.
You're saying that the great aunt and uncle go back to Pennsylvania and the reporting requirements of a form that said you're disqualified
But again, and I think this is the conundrum with the ICPC. They were disqualified to adopt because Pennsylvania has a statute that addresses the verification of employees that work with children, volunteer with children, foster parents, and adopters. The statute in Pennsylvania does not say guardianship. And I think it makes, I'm not standing here to suggest that the ICPC is wrong. I think we all recognize that there's a need for DCF when they place a child in a family in another state. There is a need for a mechanism to keep eyes on that child and to be assured that that child is going to receive necessary services because that child remains in the custody, legal custody of DCF. But in this case, what the judge would have done had she allowed the guardianship petition was to make a custodial determination and give custody directly to the M family. And then under the Uniform Child Custody Jurisdiction Act, 6 months in Pennsylvania would confer home state jurisdiction on Pennsylvania, and any further issues pertaining to the guardianship could be heard in Pennsylvania. This is not an attack on the ICPC at all. This is an effort to limit its application to the statutory language so that it does harmonize with these other relevant statutes that talk about the difference between a judicial custodial placement and I misspoke, a judicial transfer of custody versus an agency placement. And I think what happens is we confabulate these things in the juvenile court, but we really need to look at them separately. And when one does that, it becomes clear that the ICPC is not intended to apply to all custody determinations made by a judge, but rather to placement decisions made by the department or another similar agency.
You said that the jurisdiction would go to Pennsylvania in 6 months.
Under the Uniform Child Custody Jurisdiction Act.
But I guess my question is just, are you satisfied that in 6 months, Pennsylvania would be like, oh, okay, well, we didn't like this before, but since they're here and since it's a guardianship and not a custody placement.
So again, but that's a vast difference. And
so, but you're satisfied that they will do the right thing?
Absolutely, absolutely satisfied, because I would go to Pennsylvania and make the same argument to them that I'm making to this court today, which is the ICPC has a very legitimate purpose as it was intended, which is to govern agency placements across state lines so that we don't have unfortunate circumstances.
But didn't Pennsylvania make a mistake the first time? Didn't they make a mistake by saying, well, this law applies?
So, maybe not, except that one of the frustrating attendants to the Interstate Compact on Placement of Children is that it is a compact, so a majority of states need to ratify any changes to the compact. Right now, the most current version of the ICPC provides for an appeal of adverse home study decisions. But I think 35 or 36 states have to join onto the new iteration of the ICPC in order for that to take effect nationally, and it hasn't yet. So, to make things even more arbitrary, had that been the issue, we probably could have gone to Pennsylvania and said, you know what, you guys are missing the boat here. This Mrs. M is a 20-year DCF social worker. Mr. M.
But aren't they missing the boat because they read the statute wrong?
No, because what Pennsylvania did what they were asked to do. They did an adoption home study.
Right, so the initial application was for adoption, right?
Only application.
And Pennsylvania said no way.
Right.
And so the pivot was to guardianship.
Exactly.
Right.
Because we have two children who have one shot at being placed together with family, and this family, by all accounts, and by this very voluminous and very thorough home study report, is wonderful. I think to penalize Mr. M for doing what we hope all criminal defendants do, which is you do something bad, you get caught, you go to jail, and you realize, I never want to be here ever again, and you turn your life around, and that's exactly what this man has done. And I think to continue to look at this 26-year-old criminal charge as being dispositive of his ability today to care for children, when he has two children, biological children of his own, and has never had any.
Preaching to the choir
Yeah,
here.
okay. Thank you.
I hope so. Thank you. Thank you, Your Honors.
Okay, Attorney Coral.
Good morning. May it please the court. I'm Tracy Coral for the Department of Children and Families. I'm here to ask that this court affirm the lower court's decision to deny the guardianships. The lower court did not abuse its discretion in finding that the guardianships would be a violation of the ICPC, where Pennsylvania had previously denied this proposed guardian.
May I ask you a question? In some sense, the case feels to me like a question about timing. So I'm wondering if you could help me with that. If the guardianship had been teed up before the question of an adoption, how would that have played out? In other words, let's say that the couple in Pennsylvania had stepped forward before DCF came forward with a plan for adoption, and they just came forward and said, filed a petition for guardianship. What would the judge then have done? And how would the ICPC have factored into that? Would Pennsylvania's view have been solicited? On what basis would it have been solicited? Can you just work that all through for me, please?
Sure. Your Honor, first I would tell you that the juvenile court is a sending agency under the ICPC. It is on the same footing as the Department of Children and Families as it pertains to the ICPC. This is extremely unusual, as you know. Juvenile courts don't typically go and take children and put them in their car and place them in foster care. So you really have to look at it and ask yourself, why under the ICPC is the court a sending agency? And that gets down to the intention. The intention of the ICPC is to make sure that children crossing state lines remain in the jurisdiction of an entity, that somebody is responsible for their safety, for service provisions, for making sure that somebody is keeping an eye on these children. And
So what would have been this? I'm just trying to get a mechanical answer here.
Sorry.
They filed a petition for, let's assume they filed a guardianship petition. The judge would have then held,
Yes.
who would have appeared? The judge would have then held an evidentiary hearing or perhaps even trial. I've seen trials, right? So would Pennsylvania's view have been solicited, and on what basis?
The court would have had to solicit Pennsylvania's view, Your Honor. What would have happened is, and I would direct Your Honors back to the fact that these children are in the permanent custody of the Department of Children and Families. They are under the court's supervision for an abuse and neglect case. Their parents' rights have been terminated. And so when you look at Regulation 2 promulgated by the administrators of the ICPC, and you look at subsection, let me see. Wrong page. I believe it is Regulation 2, subsection 2, and it talks about different placement categories. And then it goes on to, in subsection 4, to talk about court jurisdiction cases. And it specifically states that cases within the jurisdiction of a court for abuse and neglect, or what they characterize as dependency proceedings.
That's a mass regulation, or is that?
That is the regulation that are promulgated by the AAICPC.
Okay, so that's a national regulation. It's
That is
not
a national regulation, but I would also direct Your Honor to,
And it says that they need to consult with the receiving state in a guardianship situation?
what it says is that there is an open abuse and neglect proceeding under the jurisdiction of a court, that is subject to the ICPC.
Okay, so I guess what I hear you saying is if the children were not in DCF custody, but these were just children who, for whatever reason, needed guardians, and 2 guardians came forward from Pennsylvania who were perfectly suitable and filed a guardianship petition. In those circumstances, the judge would not need to follow the ICPC or consult with Pennsylvania.
I hate to give you an it depends answer, but I'm going to. If the family members or if whoever has custody of those children prior to the allowance of the guardianship falls within a subset of family members such as parents and close family members, grandparents, adult brothers, sisters, uncles, I would say that they would not need to go through the ICPC, and that's Article 8.
So it's really it's the fact that the children are in DCF custody.
I think in this particular case, and I don't want to speak because the ICPC is very broad, but in this particular case, yes, the children are under the supervision of the juvenile court. The juvenile court is the sending agency, and this meets the intention of the ICPC, which is to protect children who are subject of abuse and neglect proceedings.
Now, do you agree that there was no mechanism? It's one of the mechanisms I found myself wondering about. And again, I do not remember where this piece of random information came into my head from. But I remember that there's some mechanism for the judge in Massachusetts to reach out to a judge in a foreign jurisdiction to ask for that foreign jurisdiction's aid in a child placement situation. Could the judge have? Is there any mechanism by which the judge in Massachusetts could have asked for a merits-based evaluation of this couple by Pennsylvania?
I'm sorry, I didn't hear what you said before evaluation.
Is there a merits-based evaluation?
I don't know what that means.
In other words, their suitability as guardians, not just based on a multi-factor assessment, not just he came up with a criminal history.
Right. Well, Your Honor, I believe that is what happened with the home study that was presented to the court by the children. I believe that the mechanism for that would be, because the juvenile court is a sending agency, they would have to contact the administrator of the compact for Pennsylvania and request a home study through Pennsylvania, and that's how that would happen.
All right, so if we were all to agree, and I'm just assuming because DCF doesn't contest this, that we all agree that this couple is a good placement.
Yes.
Is there a way that this case could be remanded to ask the judge to make that request?
Where we would land, unfortunately, Your Honor, is if this case was remanded and the court made a request for an interstate home study through the administrator of the Pennsylvania compact, the same problem would arise, that this gentleman's criminal record would bar him from
Because that's just Pennsylvania's rule.
That's Pennsylvania, it's a statute. in
Right, so
Pennsylvania.
regardless of whether you phone a friend in
Right.
Pennsylvania or not, the rule would be binding on that entity as well, that judge as well. Because Pennsylvania, just as a matter of its own policy, has said, regardless of how great you are and how much you've been redeemed, and I agree that this is, it does appear that this would be a perfect placement for the kids, but Pennsylvania's rule is no.
Correct, that's correct.
So now, can I ask you about the plain language then of the statute at issue here? It doesn't actually say guardianship, and it doesn't just say placements. It talks about foster care and adoption in particular. Why expand it then?
I don't believe it's expanding it, Your Honor.
Why? What's your statutory language basis for that?
Well, first of all, I'm going to refer you to the Article 2 definition of placement, which is quite broad. It's just care with family. So then you go over to Article 3, and you look at the provisions of Article 3. And there is reference in the provisions of Article 3 to placement, and I know it does say in foster care or as preliminary to adoption, but what you have to remember about the ICPC is that this is a statute that addresses 50-plus jurisdictions. And so the language has to be construed very broadly, and I believe Article 7, it says something to the effect of construing it broad, or actually, it might be Article 10, don't quote me on that. But when you look down at subsection D of Article 3, it says, child shall not be sent, brought, or caused to be sent or brought into a receiving state until the appropriate public authorities in the receiving state shall notify the sending agency in writing that the placement is not contrary to the interests of the child. So I think that gets you where you need to be right
Where's
there.
that provision? That's what provision you're reading from?
Subsection
That would
D.
be under Article 3, subsection D. And I also want to point you to the definitions section of the administrators of the ICPC. They have a definition section of their regulations. And in regulation number 2, let me see, regulation number 2, they have a number, I'm sorry, there are a lot of regulations here. In their definition section, they define foster care. And foster care is also defined broadly under the regulations of the AAICPC. And that definition, Your Honors, says that it is, a foster placement is essentially substitute care, and licensure and payment are not condition precedent to it being a foster home. So they're not looking at foster care in the traditional sense.
Guardianship is a concept that's got to be applied in all 50 states, right? And
I agree with you.
words they're familiar with.
And I do believe that a guardianship is, well, first, I think that Article 8 deals directly with guardianships, correct? In that it specifies that you have a number of close relatives and guardians who can make placements without complying with the ICPC.
And these people don't meet that definition. Great aunt and uncle is not.
No, they do not meet that definition. And I would add that
Does that
under...
apply even if the child were in DCF custody, or it only applies when it's a transfer from one family member to another?
It only applies when it's a transfer from one family member to another.
So is the, I mean, everyone's heartstrings are legitimately pulled here, but is this fixable in Pennsylvania? I mean, we're doing backflips and
I know.
triple jumps and.
I know.
And is this something that is clearly, you bring to Pennsylvania and say, you didn't really mean this, or you did mean it, and it's unconstitutional? I mean, are we the wrong forum for this?
I can tell you I agree with counsel. I don't see any ready way to appeal this decision administratively.
In Pennsylvania?
In Pennsylvania, and there is not, from what I could tell in my research.
Certiorari equivalent.
That says if there's no other remedy, you can't do blankety blank? I mean, it's hard to imagine there's something unconstitutional that can't be challenged.
Well, I can tell you, when I was doing my research for this brief, that I did see cases where school employees challenged this particular statute as unconstitutional. So there is a chain of case law related to educators. But I did not find anything in the case law related to foster parents and whether this statute is unconstitutional as it would apply to foster parents, especially kinship foster care.
Counsel, before we lose you, can you just address the issue of the great aunt and the great uncle not being part of these proceedings?
Yes, I was going to address that. I got sidetracked. I think Tara is directly on point.
Well, except Tara, we had no statement of interest or continued interest.
Correct, we did not, but.
So here we know that the guardians are still interested in being guardians.
And that is true, but.
So we don't have the problem in Tara where the appeals court just didn't know if the guardians had said, well, we tried, we're no longer interested, we're going to go home.
And that's a fair point, Your Honor, but I would just point you to the other part of the department's brief where there's discussion about, because ultimately Pennsylvania deems whether or not this is a violation of the ICPC, and if these children require services and they're in Pennsylvania in the future, and I think given the history and the factual history of this case, it's likely that they'll need services. Pennsylvania can deny them services if they feel this was a violation of the ICPC. So really the question for the guardians is, if they deem this a violation of the ICPC, can we assure that these children will have services going forward? Do you have the financial resources to provide services going forward? Now, I'm not advocating that that's the direction the court should go. I think firmly this is a violation of the ICPC and that the court was correct. But if that is a direction you were going to look at, the problem here is that the guardians are not here to answer questions about that. And I think in this case, they really do need to be here. Rules 3 and 4 in Juvenile Court Rule 20, there's a reason why we look for formal notice of appeals, and that parties need to be here at court, and that's to answer those kinds of questions. They're not here. So I would say that Tara is specifically on point, and they are necessary parties, as I just explained, and that this should not.
So if we ruled on that basis, we would dismiss the appeal, I take it?
Yes.
And would that preclude a whole reinitiation of a similar guardianship petition? What if they filed a guardianship petition in Pennsylvania?
Well, the problem with that is that the department is the custodian at this time under Chapter 119, Section 26. The department has permanent custody of those children, so we would have to.
So they would have to file the petition here?
Yes, they have to file that petition here.
But would our dismissal of this appeal, because they weren't present, preclude them refiling?
I didn't see anything in the docket that indicated to me that the petition had been denied without prejudice or with prejudice. I think that would be something that would have to go back to the juvenile court judge and be argued at the juvenile court level.
But we might end up in the same situation and keep doing this do-si-do.
Yep.
Which is why the department thoroughly addressed the issue of the ICPC and its applicability in this case in its brief. And I am well over my time at this point, so I would just say that I'd ask you to affirm the decision of the lower court. And to the extent I didn't get to discuss all of my points, I would rest on my brief going forward, and I thank you for your time today.